Do you just need to have it for your records?
Sure. Thank you so much. I appreciate the opportunity to speak with you. And now I kind of understand what's going on. And so just kind of tell me how you want to proceed. I will
Absolutely.
say that I read the Attorney General email. Uh, excuse me for a second. The Attorney General of Georgia is not being forthright, where he says that this is being politicized. And excuse me, I'm scrolling down to the email. Say, yeah, there's a release from the Georgia Attorney General Chris Carr's office, and he says that the lawsuit referenced in no way, shape, or form would affect Georgia's existing 504 disability program. The lawsuit would not end 504 protections for Georgia students. Well, I've been reading in some other articles that he did not respond to the news questions about the issues in the complaint, where they specifically Page 37 of the lawsuit, right there. Section 504 is unconstitutional. And then it goes on into legal theory about spending clauses. And then on page 42 of the lawsuit, it says, declare Section 504, 29 USC 794 unconstitutional. It is black and white, clear that they are trying to upend and rule Section 504 unconstitutional. So why isn't the Attorney General of Georgia answering those questions by other news outlets specifically? It is in black and white in the lawsuit. I assume you have a link to the lawsuit. So,
Yeah, absolutely, I do. So definitely want to kind of dig into some of this. First thing, before we start with any questions, if I could just have you, obviously I know your name, but if I could have you state and spell for the record and then give me your title.
yes, ma'am. I'm an attorney, Roland Mumford, Mumford. And I have law offices in Tennessee and in Savannah, Georgia. I'm actually moving to Savannah. I have an office in Richmond Hill and a satellite office in Savannah. And I have litigated IDEA cases and 504 cases in federal court representing students with autism. I'm the father of an autistic child and representing students with other disabilities. So this hits home for me personally.
Yeah, I can tell it's, something that, sparks some passion for you. Absolutely. And, a lot of people as well, kind of the same thing. What you mentioned, the main concern that I'm hearing from a lot of parents is that they're saying, the Attorney General's office, and, I spoke with them earlier today. They're saying constitutionally this doesn't affect 504 plans at all. But then parents are obviously concerned that it could affect their child's plan. So, you said you had looked at the lawsuit and kind of you feel like the Attorney General is not being forthright. Tell me some more about that.
Well, I don't know how to be more clear. It's in the lawsuit. It says specifically declare Section 504, 29 USC 794 unconstitutional. And then on page, it says count three. And then it goes into all these long listing theories about recipient of federal funds, coercion of state government agencies through the use of federal funds. It's too difficult to explain the legal theories in an interview, but it is absolutely 100% clear they are trying to rule 504 unconstitutional. And for anybody to say that that's not the case, they're not being truthful. I mean, read page 37 through page 42 of the complaint. You can go online. It is very clear. And they all throughout the legal argument, they say that it is unconstitutional and develop their theories under the spending clause arguments. So, where this all started was a case out of Williams v. Kincaid, ruled by the Fourth Circuit Court of Appeals, and they established that gender dysphoria can be considered a disability under the ADA in Section 504 if it results in a quote clinically significant distress end quote due to a disconnect between an assigned sex and gender identity. And now the court emphasized that gender dysphoria is distinct from simply identifying as transgender, and not all transgender individuals experience significant distress from gender dysphoria. So it's very important to understand that this issue is going to gender dysphoria, and in all the legal arguments and in the facts surrounding the claims are distinct from the issue of gender identity. And it's very important that that be communicated. And what they're trying to say is uh, that there are issues with children having gender dysphoria, that there are issues of emotional distress, depression, and other psychological symptoms arising out of that, and that they wanted that to qualify as a disability under the ADA and Section 504. President Biden then tried to go in and expand the definition of disability under the ADA and 504. Normally, what that definition is, does the disability substantially impair the daily life routine activities of a person? And so that's where they're trying to bring dysphoria in, and they're trying to bring this issue of any emotional distress that arises out of that and to qualify under the term of as a definition of disability. I have a civil rights practice and employment discrimination case, and I have litigated disability cases under the ADA and Rehabilitation Act for 18 years. And so this is a very interesting question. But usually that's what they're trying to say is that this is a disability that where these children, the dysphoria is affecting their daily life routine activities. And obviously they define it as, quote, clinically significant distress, end quote, again, due to a disconnect between the assigned sex and gender identity.
So I think that's really important background to have about what exactly the language is saying and what exactly it would mean. Speaking, from a standpoint of, if this lawsuit, I'm sure it'll be challenged multiple times, it'll go to multiple different levels of courts. Is this something that like could actually, go further and like eliminate 504 plans essentially?
If the lawsuit is successful, this would effectively be the end of Section 504 and would free states from having to provide students with disabilities their civil rights under Section 504. Under, of course, Section 504 of the Rehabilitation Act codified the civil rights of persons with disabilities. The law has been very important to students with disabilities because it protects students covered by IDEA, which is the Individuals Disability Education Act, which I've litigated for many years, and even protects students with disabilities who are not covered by the IDEA. So this would affect not just students under Section 504 in schools with a disability, but it could have an impact upon people in certain types of medical facilities, nursing homes, assisted living centers where uh, they receive federal funds. And if they are under a Section 504 kind of plan, this goes beyond just schools. It can impact adults with disabilities, and they're in some kind of therapeutic environment or treatment or such other, where the facility or they're under a grant, something where it implicates federal funds. It's wide ranging, has wide ranging effects.
And, so hearing from the Attorney General when they said, this doesn't affect the constitutionality of 504, how does that, I know you kind of mentioned it's pretty clear that they're not being forthcoming, but what could be the legal argument behind what they're saying that it doesn't affect the constitutionality behind 504 when it looks like the language pretty much plainly states that it does?
Well, that's a question for the Attorney General's office. And there's another case that's coming out of from a Georgia prison inmate where they're trying to implicate uh, transgender identity or dysphoria. That one I need to look into a little bit more, but they want to implicate that as a disability under the ADA because they want to get treatment for certain things. But that's a whole other conversation. But to answer your question, the Attorney General's just not being forthright. I mean, read the lawsuit. I mean, it's right there. I'm assuming you're going to put a scan of this lawsuit up on the screen and highlight it. It's very clear. Read it. You don't have to read the 43-page lawsuit. Read pages 37 through 42. It's in black and white. So, and then I've read where many other reporters have been asking that specific issue to the Attorney General of Georgia, and they've not responded to that. That email or that press release by the Attorney General is not forthright. It is black and white. Again, declare Section 504, 29 USC 794 unconstitutional. I don't know how more clear to be.
Yeah, absolutely. No, I think, and you discussed as well, kind of how it can have these wide-ranging effects beyond children in schools. It can, affect adults that are, in any sort of, like you said, therapeutic environment, facility, et cetera. It kind of expand on that for me. It just, what this would mean for, you know, wide-ranging, not just in Georgia, but around the country.
That's the students under 504 plans. Yeah, so there are students with disabilities that have what you refer to as an IEP, but that goes very often to instructional issues where they get extra time privileges and assistance as regarding the academic part of being in school. Section 504 goes to accommodations within the school. That could be different things. Usually it implicates a physical disability, but very often disabilities such as autism and other mental health issues. And so this would have a tremendous adverse impact on students with disabilities that are under a 504 plan, and it would give greater license to schools to violate their rights as they're already doing with the IEP issues. I mean, schools routinely take advantage of parents' ignorance of the IDEA law, where they're not having proper IEPs in place for those students, and these parents cannot afford attorneys such as myself or have to hire advocates to go out and have these IEP meetings with the teachers. And then if the school doesn't want to agree, then these parents have to go through a state administrative process before they can get to federal court to have an IDEA lawsuit, which I've litigated. But under 504, you're dealing with accommodation issues, whether it might be a physical accommodation to assist a student, or maybe another type of an accommodation to assist a student that, like I said, has autism or another type of a disability that's not quite physical. But that could be so many different things. It'd be hard for me to get into that in a brief interview. It would just depends on what the specific accommodations those students have. Obviously, if this is abrogated, if Section 504 is abrogated by the Supreme Court or in this lawsuit, because this will obviously go to the Supreme Court, those students are not going to be allowed those accommodations by the schools. Now, there are states that have state laws that build on Section 504 and extra protections for the students. So there could be so that adverse impact if 504 is deemed unconstitutional, then there could still be some relief for the students in particular states if there are state statutes that have parallel laws regarding the relief provided by 504.
And the current administration, in a lot of these, controversial issues, the whole thing has been leave it up to the states. So, in talking about how certain states have specific 504 laws that go beyond anything federal, is that maybe what we're trying to see happen here? And is this becoming another issue of, leave the legality of it up to the states?
Well, I think from reading page 37 through about pages 40, the majority of the arguments that these 17 states are claiming uh, is regarding spending issues and then coercing the states through the spending. Because, for example, in any kind of education matter, the Department of Education can't tell the state what to do. Just like a Department of Transportation federally cannot tell a state what to do. How they do tell the states what to do is by saying, well, if you want our federal dollars, then you have to do X, Y, and Z, and they attach the rules to the funding. And so that's if that answers your question. But clearly that's where they're aiming at. But there's some other reasons. I mean, they're getting into count four about issues of quote the final rule, but we're getting into legal theories that are beyond the scope of this interview. They clearly want the Section 504 unconstitutional.
Absolutely. That's, that it's really jarring to think about when, you have the different rhetoric going on from different areas that are saying one thing and saying the other. My last question to you, was there a way for them to go about this if they specifically wanted to eliminate the language for, gender dysphoria from that 504 capability that people have? Was there a different way that they could legally have gone about this as opposed to trying to eliminate the entire 504 plan?
Well, yeah, President Trump could have administratively or through by executive order altered that language, basically undo what President Biden had done. Yes. But for some reason, they want to go beyond that and want to rule Section 504 unconstitutional. Period. That is clearly their goal. And, one quote is, quote, because Section 504 is coercive, untethered to the federal interest in a disability, and unfairly retroactive, quote, the Rehabilitation Act is not constitutional, end quote. I don't know how much more to be clear.
Yeah, absolutely. Thank you. I think that's really important context for people to have because, sometimes with these legal documents, I think it's easy for people to feel a little bit like intimidated by it, but just breaking it down to the plain language is really helpful. So thank you for that. Those are all the questions that I had, unless there's anything else you think, is important to add about, details or pieces of context that people should, understand when they're trying to read this litigation.
This is going to be a mess for school districts in Georgia regarding special education. This is going to be a mess. Thank you very much.
Thank you so much. I appreciate your time.
You take care.